Good afternoon, everyone. The good news is we didn't have a very vigorous landlord-tenant docket this afternoon. We had several cases that were resolved. The bad news is we have 4 general civil cases all set for 1:45. Mr. Barta, which case are you on here this afternoon?
Good afternoon, Your Honor. I'm here on Portfolio Recovery Associates versus Sean Hayes.
All right, Mr. Hayes is with Mr. Rognus at the home there. We may have to let you guys talk for a minute. Mr. Jamal, you're on LVNV funding and Citibank.
Correct. I just have one LVNV funding matter with Ms. Brown, and then Citibank versus Hopkins. Or sorry, Citibank versus Merriman.
All right, we've got both of those parties here. We have an asset discovery hearing for Mr. Rognus as well. All right, well, let's start out with Mr. Barta and Mr. Rognus's case. Let's see where we are. This is entitled Portfolio Recovery Associates versus Sean Hayes. The amount at issue is $674.37. Mr. Rognus, is Mr. Hayes there with you?
He is, Your Honor. And did you get an opportunity to review the reply brief?
I did.
Okay.
This is a motion for summary disposition. The lawsuit was filed. Mr. Rognus filed an appearance on behalf of the defendant and filed a general denial denying the debt. The amount at issue was only $674. This matter seems like it could be resolved. Mr. Barta, are you willing to discuss the matter with Mr. Rognus and his client in a breakout room?
Your Honor.
Is that agreeable with you, Mr. Rognus?
Initially, Your Honor, the Davidson matter, if Arden Davidson has appeared, the asset discovery.
He isn't here.
Mr. Kemp isn't there?
No.
Okay. And none of the people at the security desk have seen him?
I don't know. I haven't checked yet, but let's deal with this one first.
Sure.
Then we'll do Mr. Jamal's cases, and then we'll talk about your asset discovery case. As I said, fortunately, we don't have any more landlord-tenant cases. This is quite a few cases crammed into a small amount of time. All right, let me set up the breakout room. I'll put Mr. Rognus, Mr. Barta, and their client in the breakout room. You guys can discuss this $674 debt. Meantime, I'll work on Mr. Barta, Mr. Jamal's cases. All right, I'll be here when you get back. Of course, the problem with that is I've now assigned the breakout room. We have 2 cases that Mr. Joseph Jamal is here. First is Citibank versus Kate Merriman. Miss Merriman, would you join us? This is a claim for good afternoon. Let me make my note here. This is file number 252006GC. It's a claim for $2,388.20. I think this is just a pre-trial. No, there's a motion for summary disposition. I separated the file. Defendant filed an answer, which was essentially a general denial, which gets past a default but does not get past motion for summary disposition. The debt is not overwhelming. It's 23.8 plus costs and interest and attorney fees. Mr. Jamal, have you and Miss Marin had any discussion about this?
We have not, no.
Miss Merriman, are you willing to discuss this matter with Mr. Barta in a separate space called a breakout room?
Yes, Your Honor, I have made a written settlement offer and a follow-up, but I have not received a response yet.
All right, we can discuss that. Or you stay right where you are for a minute. The next matter, I should have opened more than one breakout room, is LVNV Funding versus Dorothy Brown. This is file number 251822GC. Miss Brown, can you hear me?
I can.
This is also a motion for summary disposition with costs. The total would be $3,231.09. Once again, the lawsuit was served on the defendant and defendant filed a response. In this case, the defendant is asking to compel arbitration proceedings under the contract. She contends that it does allow them to stay this matter and refer for arbitration. Mr. Jamal, what's your position there?
Typically, anytime somebody requests to compel arbitration, we don't necessarily object to that request. We just request that the defendant, being the one who's electing arbitration, be the one to actually go forward and file it. There are other requirements regarding who covers the costs, et cetera. But since we are not electing, we typically request that the court order that the defendant be the one to file.
All right. Is that agreeable with you, Miss Brown?
Yes, Your Honor.
Are you willing, short of that, to discuss this matter with Mr. Jamal for perhaps some sort of settlement agreement?
As far as I know, it was supposed to be done through an arbitrator.
Well, that's an option. And you've submitted it and you've even submitted an order referring it to arbitration. I would order that you be the one to file for the actual arbitration. And so he's not even objecting to that as long as you're the one to do it. But you're here and he's here. We could let you talk to each other in the meantime. Let's take a break and see how we're doing with Mr. Rognus and Mr. Barta. Mr. Barta, you're the plaintiff. I'll defer to you. What's our status here?
Your Honor, we've resolved it with a settlement amount, which is going to be paid. It's $350 to be paid on or before March 26th, 2026. I don't know if the court wishes to just adjourn our motion and pretrial out till after March 26th, and then we can file a dismissal with prejudice once that's paid, or do you want us to get a settlement document together into the court?
First option is easier. Mr. Rognus, do you agree with that?
Yes, sir, Your Honor.
And if I defer this to March,
You might want to pick it up into April.
April 6th,
Yeah.
2026, maybe the snow will be melted by then at 1:45. Expect settlement and dismissal.
Correct, Your Honor.
All right, let me make sure I nail this down. The claim is for $674.37. The defendant agrees to pay $350. Is that inclusive of costs?
Yes, sir, Your Honor.
Yes.
Mr. Hayes, you agree to that?
Yes. Sir. Sir.
You're gonna pay that before March 26th, which is 2 months from now. If that is paid, plaintiff will dismiss with prejudice. If not paid, we'll have the hearing on the summary disposition motion on April 6th at 1:45. Is that acceptable to you, Mr. Barta?
It is, Your Honor.
All right, thank you. And thank you for logging in and discussing the matter. I'll
Thank
see you
you.
next time. You seem to
Have a
come
great day.
a couple times a month as punishment. They send you out here and maybe one day you get to come here for real again. All right, I'll see you next time. Thank you.
Thank you.
All right, same thing with Mr. Jamal. He comes out here a couple times a month, whether he wants to or not. We were talking at first about Dorothy Brown. And she was requesting mediation or arbitration, which defendant does not object. We're gonna table that one for a minute. We're gonna put Miss Merriman and Mr. Jamal in a breakout room, and then we'll make a record on Mr. Rognus's discovery. So Miss Merriman, I'm gonna assign you to a breakout room. When you see the button that says join, click on that and I'll put you in with Mr. Jamal and you guys can discuss this matter and this motion. You've apparently made an offer and you guys can discuss that.
Thank
So
you.
you should be good to go if you just join it. Oops, yeah, you're good.
Okay, thank you.
Judge.
All right, Mr. Rognus has also filed a discovery subpoena in the matter of Arden Davidson versus Joe Kemp. The file number here is 252140.
2104.
2104, yes, thank you. The judgment is substantial for district court terms, $15,000 plus costs for $15,292.80. Judgment entered on October 28th of 2025 by default. And an attempt to collect on that debt, Mr. Rognus has tried to garnish some from bank accounts and other things. He filed it for a debtor examination for today. And that is Monday, January 26th at 1:45 p.m. That subpoena was personally served by Adam Kraft on January 14th at 4:45. The defendant is not here. Let's call. I don't have you to yell the hall 3 times, Andrew, so I have to call the
That's
bailiffs.
true. I could yell, but it's not going to do any good.
Hello, Deputy Broker. I'm looking for Joseph Kemp, who's supposed to be here on a discovery case. All right, thank you. Bye.
Request a bench warrant, Your Honor.
Plaintiff, defendant failed to appear for discovery, personal service. It is snowing like crazy out there. It's 4 degrees and all the schools are closed. There may be a reason why he isn't here.
Yeah, but he's had my phone number this entire time.
Say that again.
He's had my phone number the entire time. Certainly could have got in touch with us when he got the garnishment disclosure.
Well, he has not. Let's see what we're gonna do. I'm gonna set an order to show cause first.
Okay. What date you want it?
I'd like to do it next Monday. Let's see if you're here for anything.
What's the date next Monday?
It's Monday, February 2nd.
Okay, then. Is that, bar meeting on that day?
I think so. No, second Monday of the month.
Okay, okay.
Apparently, Matt Davidson was working on a nice meeting. It doesn't look like you're set for anything, Andrew, but we could
It's gonna
set this
be
for
by
one
Zoom anyway,
forty-five,
so.
February 2nd. Does that work for you?
February 2nd, 1:45, you said,
Yes,
by Zoom?
yes.
You're gonna send the show cause order out?
Yes,
Okay. So I don't have to do anything? The clerk will do that?
yes, you just need to show up. If he's not here at that time, I will entertain your motion for a bench warrant. So if anybody knows Joe Kemp from Sturgis, I'd advise he call Mr. Rognus. His phone number is written all over Sturgis. It's in the book. It's in his pleadings. And otherwise, we'll have a show cause hearing next Monday at 1:45. And if he does not appear at that time, I will entertain Mr. Rognus' motion for a bench warrant.
Good enough, thank you.
All right, thank you.
The courtroom was quieter than usual, but the tension was still there. A debt of just $674 brought both sides face to face, and instead of forcing a judgment, the judge pushed them to talk. Minutes later, a settlement was reached for nearly half the amount, proving that even small cases can have big turning points when the court steps in.
All right, Ms. Brown, it's just you and me. Let me put you in the waiting room. We'll see how they're doing in the breakout room. All right, Mr. Jamal and Ms. Merriman have returned from their discussion in the breakout room. Mr. Jamal, how did we do?
We did good, not great. We made some progress. I think today, if possible, Judge, if we could get a 30-day adjournment, there's some settlements and payment information that needs to be reviewed. But like I said, I think we are making progress. We hope to have this matter resolved. If it is before the next hearing, we'll submit the proposed conditional dismissal we discussed prior to that hearing.
All right, well, the motion for summary disposition did have merit, but if it can be resolved, I'm all in favor of it. So let's see what we got. I said you have to come every month or so. I guess you're stuck here again in February. Today is January 26th. Well, that takes us to March. How are you for March 2nd at 1:45?
March 2nd will work for plaintiff.
So work for you, Ms. Merriman?
Yes, Your Honor.
2026 at 1:45. Parties will continue to work towards settlement. Ms. Merriman, are you still at the Nottawa Street address?
Yes, Your Honor.
And you guys have each other's contact information?
Yes.
You agree, Mr. Jamal?
Yes, we did, or I did exchange and receive Miss Merriman's email. I'll be sending her one shortly. She'll have mine at that time as well.
Well, we won't lose anything by adjourning this matter for 30 days. So let's continue it to March 2nd at 1:45 and give you guys an opportunity to settle it. If we do, great. If we don't, we'll hear the motion at that time. Ms. Merriman, you're good to go.
Thank you.
Thank you.
All right, thanks. All right, let's return to LVNV funding versus Dorothy Brown. File number is 251822GC. The claim, as I indicated, was for $3,058.78. If we include costs of $172.31, total is $3,231.09. Defendant filed pleadings indicates that she elects arbitration in this matter as the credit card agreement provides for. She did provide a notice of election of arbitration and a proposed order to stay proceedings pending arbitration. Mr. Jamal had no objection to that, provided the defendant was the one to file for the actual arbitration. before doing that, I inquired whether there would be any merit to having the parties talk in a breakout room. Ms. Merriman, Ms. Brown, do you have any objection to that?
No, no, Your Honor.
All right, well, let's try that. We'll see where we are, but we can always refer it. Again, I'm gonna put you both in the breakout room. All right, everybody's back. I've been working on another project. My apologies.
Not a
All
problem.
right,
Thank you.
Mr. Jamal and Ms. Brown are back after a short stint in the breakout room. Mr. Jamal, do we accomplish anything?
Yes, we did. We have agreed to terms of settlement. I've got to put some documentation together. We're gonna do it via conditional dismissal, similar to what we mentioned in the last matter. If maybe we could get another adjourned date, same day as the last one, I hope to have this one off the docket. I've prepared the documentation already, so hopefully it's a pretty quick turnaround.
Another case wasn't so simple. A credit card debt over $3,000 turned into a legal standoff when the defendant demanded arbitration under the contract. The judge agreed, but only if the defendant took responsibility for filing it. In this courtroom, the message was clear: know your rights, because the rules can change everything.
Do you agree with that, Ms. Brown?
Yes, Your Honor.
All right, we set Ms. Merriman for March 2nd at 1:45. Does that same date work for you?
Yes, Your Honor.
And conditional dismissal before that time.
And as you write that down, Ms. Brown, is the address the same as it was prior? So the 223 address?
Yes.
Okay, great, thank you.
You're welcome.
All right. Ms. Brown, do you have any questions?
Not at this time.
Are you going to get a notice for a new date, March 2nd? In the meantime, you guys are going to work on this. And if it's resolved, there'll be something called a conditional order of dismissal filed dismissing the case. And that'll take care of it. If it isn't, we can always discuss your motion for arbitration and the summary disposition motion on March 2nd. All right, Mr. Jamal, thank you for your time this afternoon. Ms. Brown, thank you for your patience.
Thank you.
All
Yeah,
right.
thank you all.
Bye.
Have a good rest of your day.